Thank you. You may proceed. Thank you, Mr. Littlebase.
The gist of this matter, Your Lordships, I just want to reply to one of the aspects that was raised by the first three applicants in this particular matter with regard to the owners. If the court takes into consideration the ground that was raised with respect to the owners in bail application, that can be found in paragraph 13 of the notice of appeal. And the instance thereof was that the court erred in finding that in a bail application, the owners lay with the accused person to show that he should be released on bail. So it was not in relation to the constitutional provisions that were in a constitutional breach and Article 12 is alleged. Then the owners lay with the state. That is not the ground of appeal. Therefore, on that basis alone, I've referred to the matter of Avital, the surname I cannot properly pronounce, but in that particular matter, what the court found was that if a notice of appeal has not been amended, then whatever is going to be argued by a party, which is not part of the notice of appeal, which crystallizes the issues, then it should be ignored. So I respectfully submit, Your Lordships, that on that basis,
Appeal are you talking about?
Excuse me, Your Lordship?
Which paragraph of the notice of appeal are you talking about?
Paragraph 13, Your Lordship.
13?
Yes, Your Lordship.
That's the first to third appellants?
Yes, Your Lordship. So I respectfully submit, Your Lordship, that on that basis alone, that argument should be disregarded. But if the court wants to have regard to it, I don't know, because it's in the discretion of the court, if the court raises it, which has not been done in this particular case, would submit that the owners, even in terms of Article 12, still lays with the applicant. They are the ones who are alleging a breach of a constitutional right. They must prove that breach of constitutional right. So they have the owners, and that is the legal position in Namibia. We have the matter of state versus Heidenrecht, which has dealt with that, and it considered the constitutional principles, and that was the finding of the court in that particular matter.
They have been permitted to raise the issue collaterally.
I do not see an issue with that, Your Lordship. They would have been permitted to do that on its own. They would have, Your Lordship. I don't think that is an issue.
Because in other jurisdictions, if an appellant, or rather an applicant and accused in court, considered that their constitutional right is implicated, they are permitted to can file a collateral application to challenge the issue so that they place it before court for determination. But in other jurisdictions, you are told you cannot raise such kind of thing in proceedings where, like for example, in criminal proceedings, you can't raise such a point. It is unacceptable. And they would say, well, you have to file a proper motion procedure in order to challenge that in a court having the necessary jurisdiction to entertain the matter.
Lordship, that would have been a proper course to take in this particular case.
You also do it in Namibia, the latter.
Insofar as Namibia is concerned, we've not had a bail application. I'm not of, in particular, a bail application that has been held with reference to the release in terms of Article 12. The cases that I'm aware of, those have been separate applications on their own, wherein the accused persons are set their rights in terms of Article 12 in a separate application, not a bail application. In this particular case, we're concerned with a bail application proper, not necessarily the release of the person in terms of Article 12 of the Constitution, Your Lordship.
In essence, what you are saying is that, well, there was never such an application in KASU, and therefore they can't argue the issue the way they do it. And if it had been raised in that manner, then the state would have had an obligation to explain itself. Otherwise, the complaint has no merit. Is that your argument?
Your Lordship, unfortunately, for purpose of these proceedings, as we've already alluded to in the House of Arguments that they had the owners, they did not produce the record of proceedings indicating the remands in this particular case from the first appearance until the day the bail application was held to see what had occurred in this particular case. We had an application before I argued that application regarding the release of the applicants in terms of Article 12. That was a separate application that was dealt with before. But unfortunately, I did not want to deal with that because it's not part of these proceedings, but there was such an application, Your Lordship.
Thank you.
As it please the court.
Mind just raise your voice a little bit.
As it please the court, Your Lordship, I'll try to speak louder.
Okay.
I will speak louder, Your Lordship.
No.
Oh, yes, it's a much louder voice than mine. Your Lordship, the purpose of this appeal, the main reason as to why we are here today, is to ascertain whether or not the judge in the High Court was wrong in his decision refusing bail to the applicants. That is the main reason that we are here today. I know there have been numerous issues that have been raised in the notices of appeal for the first three applicants and for the last three applicants in this particular matter and in the heads of arguments. We've dealt with those sufficiently. I do not intend to regurgitate each and every point except those, some of them which have been touched where we need to rectify.
I'm to hear you.
Your Lordship,
Doesn't help
maybe...
to mumble to yourself. I think you must talk to us.
All right, Your Lordship, what I'm saying is that in respect of this particular case, there are numerous grounds of appeal that have been raised by all six insofar as this case is concerned. That was the basis on which bail was denied. Now, this court has to ascertain, was the court wrong or right in reaching such a conclusion? And the court has to do that in the context of the evidence that has already been laid in the High Court. The test on appeal, Your Lordship, I've already referred to the matter of Elias Sangombe versus the state in paragraph 49 of the state's heads of arguments, where the court in instance indicated that the test under section 65.4, the question is whether the decision to refuse bail was wrong or not. And the court went further to say that even if there are material misdirections contained in the reaching of that conclusion has occurred in this case, in the Hangombe matter, this court is still required to consider the question as to whether the decision itself was wrong or whether bail should have been refused or not. That is what the court has to consider. Now, looking at the evidence that was placed before the High Court, Your Lordships, I'll just briefly summarize to illustrate to this court that the court was in actual fact right in its conclusion in denying bail to the appellants. We know in respect of the second appellant that he has a pending case of obstructing the course of justice and charges of bribery that is pending against him. And we know the allegations against him in that particular matter is that he sent an agent to bribe officials of the ACC with 250,000 Namibian dollars in order for them to release exhibits which were in their custody to him. These are exhibits which have been seized in terms of the law. He wanted them to be released to him. There is that evidence which is available before court. So we are not really only dealing with a likelihood when you look at this particular appellant. When we look at this, there is actual evidence of interference, which is there that the court has to take into consideration in deciding whether or not to release the appellant on bail. And this is what the court, ACO, had to consider, whether or not there's a likelihood of interference with investigations or witnesses or with the case itself. Because in this case, we are dealing with exhibits which are already in the custody of the accused person, not necessarily potential witnesses in the custody of the ACC, not potential witnesses and so on. Evidence was also laid with regard to information that was found on the accused person's cell phone, where he was hatching plans to manufacture documents with regard to delivery of fish in Angola. And this was done prior to him being arrested. After his arrest, that is when he tried to bribe the members of the ACC. So at least we have a glimpse of what he's likely to do if he's released on bail. Because when he's a free man, he has more resources to try to interfere with this matter and manufacture documents if need be. And that would be very prejudicial to the administration of justice when false documents are being presented before the court. I also just want to highlight that insofar as this particular appellant is concerned, there's evidence that was laid to Mr. James Atubilipi. Evidence was also further laid that on 2 separate occasions, not once, but twice, in 2010 and in 2020 and 2021, evidence was laid that on 2 separate occasions, while in the custody of the correctional facility, he was found in possession of cell phones, which is not allowed in the correctional facility. So this person, very well aware of the rules and regulations, the laws governing the correctional facility, on the first occasion is found with a cell phone. Fine. Does he respect the rules and laws which govern the correctional facility? He does not. He is still found with a cell phone on a second occasion about a year later. So in instance, what that illustrates is that this person has no respect for the law. So even if this court was to consider imposing bail conditions, what guarantee is there that he's going to adhere to those conditions? Because he has shown, and that evidence is there, that he's not going to obey rules, regulations, laws. So really, the court will be at the mercy of this person, and it will just be a matter of praying that he does not interfere, because the evidence itself shows that he's likely to interfere, and he's likely not to follow any bail conditions that may be imposed by this honorable court.
Do we have anything on record to show that while he was in possession of a cell phone, he attempted to contact a particular witness with it? Yeah. Or whether there was any communication or whatever? It might be he violated the prison regulations, which may have been unfortunate, but did he use that phone to contact another person, a witness, or would be a witness in this case? Is there anything to that effect?
Is concerned, from the evidence that was laid, no, that is not the case. From my recollection is that the contact was between the first appellant and the second appellant. So there was no evidence that he attempted to contact witnesses. What I want to highlight, this evidence was not laid to show that there's a likelihood of interference. It was laid to show that even if the court imposes bail conditions, he's likely not to adhere to those conditions because of his conduct at the facility, Your Lordship. The issues of interference, that evidence has been laid with regard to the charges that he faces of obstructing the course of justice and bribery of the SEC officials, persons who are investigating his case. So the issue of interference has already been sorted out with the pending case. Now, this evidence shows that he's not likely to adhere with bail conditions, Your Lordship. That was primarily the reason why this evidence was laid. And I just want to highlight, Your Lordship, that insofar as his phone is concerned, we heard from the evidence that was laid, which is on record, that there was nothing on his phone. The information was deleted. So unfortunately, it cannot be said whether or not he tried to interfere or what he was using that phone for. It's unknown. So if he's so cunning to keep such information away from the prison authorities, what more if he's released on bail? Because if we cannot find that while he's in custody, really, we will not find anything wrong, and we will never know that interfered if he's released on bail. I also just want to highlight, Your Lordship, that insofar as the first appellant is concerned, equally, he faces charges of obstructing or defeating the course of justice. Similar to the second appellant, these charges arose while he was in custody. So this goes to illustrate that no matter where they are, the likelihood of interference is high. But if they are released on bail, really, there's nothing that anyone can do to stop them from interfering in this matter. And the charges that he faces in respect of this particular case, he had also sent an agent to remove documents from his premises which were relevant to the determination of this matter. So there is evidence of a likelihood of this particular appellant as well interfering with this matter, either with the evidence, with the witnesses. That likelihood is there based on the charges that he faces. Now, we also laid evidence that he too was found with a cell phone in the correctional facility. This is a former minister of, yes, appellant one, Your Lordship, that he too was found with the cell phone in the correctional facility where he's held. Fortunately for the state and unfortunately for him, there was information which was found on that cell phone. And the information revealed that he was conducting research with regard to extradition. And not just any extradition, and not extradition from any other country, but in particular extradition from Dubai, the UAE. That is the research that was being conducted by the first appellant. We know there's evidence before court, and this evidence has never been disputed. The appellant chose not to testify, so this evidence remains undisputed. That 75% of the usage fee in terms of the agreement that one of the accused persons, Mr. Gustavo, signed, which is not, who is not before court, was to be paid to a company to Davala, Dubai. From the proof of payments that were submitted before court, and from the evidence of the investigating officer, it was testified that at least an amount of $4.1 million was paid to an entity, to Davala, where the second appellant has an interest in Dubai. Now, the whereabouts of those funds, they are unknown at this stage. They have not been recovered. So really, at the end of the day, we have this person who's a lawyer by profession, was a former attorney general, a former minister. He knows the law. He knows extradition. There's no doubt. He worked in the Ministry of Justice. So issues of extradition, he knows what that is. And he knows we do not have an extradition agreement with Dubai. So when we have regard to his conduct and his gestures on the phone, first and foremost, I'll deal with the issue of absconding later, but it shows that there's an intention of this person to abscond because there are funds, there are possibly funds in Dubai in the benefit of the syndicate. Secondly, what this shows is that there's a likelihood of him also interfering with the recovery of those funds. If he goes to Dubai and does whatever he wants with those funds, well, that's the end of the matter. I respectfully submit, Your Lordship, that on that basis, the High Court did not err in its decision in finding that there is that likelihood of interference, and it's not in the interest of the administration of justice to release the appellant on bail. I just want to also highlight that in respect of the fourth appellant, much was said in arguments that the version by the state regarding interference with Mr. Kamano was never put to him. Your Lordship, that version was put to him, and Mr. Kamano's statement was read to the fourth appellant with regard to the issue of interference in relation to the consultancy agreement. Your Lordships, I'm not going to regurgitate everything that was said regarding the interference, but that can be found from page 902 of the record, volume 8, and it goes all the way to 907 of the record. That is where that version was put. I just want to clarify that that version of interference with regard.
I thought you were actually going to show us where it is said that they did the sort of things that you are referring to. because we were given the impression that statements, empty statements are being made against this poor appellants, and 3, 4, and 4, 5, and 6. Yes. And I thought you were going to say, this is not correct. Look at what you have here in volume 7. Yes.
As it plays the court, Your Lordship, I can do that. Then if the court will just bear with me, because I'll need to get the page numbers where that was said. I want to start off with the statement of Mr. Kamano.
.05 and 1216, that's what Mr. Pakela referred us to.
Yes, Your Lordship. I just want to...
As far as I can recall, my notes are correct.
He was referring to the judgment.
Oh, was that the judge?
756.
No.
Page 756.
Yeah, the statement of Kamani.
Yes, Your Lordship, it starts from page 1201 of that.
It's volume 8 or what?
It's volume 11, Your Lordship. I think this is Exhibit Z23, volume 11.
Just give me the page number again.
The paragraph is paragraph 40 at
Page
1201, Your Lordship.
1201.
On the exhibit.
Yes, Your Lordship, on the exhibits files. I'm referring to the statement as contained in the file itself, Your Lordship. What is indicated at paragraph 40, the title is Consultancy Service Agreement between Skeleton Coast Rolling Pty and Gwanyeme Investment Trust. This is from the statement of the state witness, Mr. Kamano. And he stipulates that during about November 2019, Mr. Ngipunya called me about a consultancy service agreement. He wanted Novanam to sign for consulting services he rendered to us. A copy of the agreement is attached here to marked as JR 153, JR 160. And then it goes on at the next page. At paragraph 41, that Mr. Ngipunya told me that the agreement would offer him and Novanam a form of safety. At 42, it says Mr. Ngipunya sent a draft agreement to me by email. I can recall the exact date when I received it. I told him that I would forward the agreement to Novanam CEO, Mr. Miguel Todesilas, as I did not have the authority to sign the agreement. And it goes on at the bottom, where he refers to contact with Mr. Ngipunya after his arrest. I'll just start from paragraph 47, Your Lordship, I think just to put everything into perspective. Instead,
You're going to read to us.
excuse me, Your Lordship?
Sorry, you say moving on to 47?
Yes, Your
Others
Lordship.
are background. 47, okay, go to it.
Yes, Your Lordship. Where did I stop at? 42? Yes, 43. Just to continue at 43, my apologies. Mr. Ngipunya contacted me a few weeks after our first discussion to follow up on Novanam's signature of the consultancy services agreement. I informed him that Mr. Todesilas was in Spain, but I would follow up on his signature once he was back in Namibia. And 44, it goes on to say that Mr. Todesilas decided not to sign the service agreement, and it was never signed. 45, he says that Gwanyemba did not render to Novanam the services described in paragraphs 3 to 6 of the agreement during the period 2017 to 2019, and these functions Novanam performs and manages itself. Moving on to paragraph 47, He goes on to say that it came to my knowledge that Mr. Ngipunya was arrested during February 2020 and has remained in detention since then. He has contacted me on my mobile phone on at least 2 occasions from prison from an undisclosed number displaying no number on my mobile screen. I recall some of our discussions have centered around the following topics. Mr. Ngipunya called me to request signature of the service agreement between Skeleton Coast Rolling, Gwanyeme Investment Trust, as referred to before. And then he goes on. Your Lordships, I think I'll just read everything that's contained on the next page because this also relates to one of the other applicants, appellants. I'll still have to deal with him subsequently. So I'll just indicate what is indicated in his statement so I do not have to come back to it, Your Lordships. In paragraph 42, it is indicated that Mr. Ngipunya also contacted me for financial assistance. He requested that an amount of 100,000 to be paid to his lawyer, Mr. Milton Engelbrecht. I informed him that I could not afford to assist him with such a large sum of money. He asked me if I can give him 80,000. I said I cannot afford such an amount of money, but would assist him with a smaller amount. I received Mr. Engelbrecht's banking details through a WhatsApp message, as far as I can recall, from a person who I knew as Oti, who told me he is one of Mr. Ngipunya's friends. I instructed my gardener to make a cash deposit in Mr. Engelbrecht's account of an amount in the range of 30,000 to 50,000. I cannot recall the exact amount. I did not keep a deposit slip. The money was paid. The money I paid was my own funds kept at home. And then it goes on in paragraph 50 to state that I received other telephone calls from Oti again. And from the evidence before court, what was disclosed by Mr. Engelbrecht is that Oti is the 5th appellant in this matter, Mr. Othniel Shudifonia. That I received other telephone calls from Oti again, asking when he can meet up with me. He also sent me a text messages asking when I would be in Windhoek again. These messages were sent on 21 and 27 November 2020. He used the number, and the number is indicated there, to communicate with me, which number I saved as a contact named Oti, Mike's friend. I attached here to the screenshot of our text messages marked JR166. Your Lordships, I just want to highlight one thing, because much has been said about a misdirection by the court that, with reference to the witness saying that it was backdated. The consultancy services agreement was submitted as an exhibit before court. And what I noticed from the exhibit bundle, it should be marked as exhibit Z22, but unfortunately, I don't know if it's only my file that does not reflect it, the agreement is not on my file, on the exhibit file, but it was submitted in court, and this is not in dispute. It was submitted with the statement of this witness as Z22. On the list, the agreement appears they should be on top of this witness statements, but it's not there. Your Lordships, I hope it's not an issue. I just want to illustrate something with regard to the backdating. I hope it's not an issue. I have a copy of the agreement with me. I just want to provide that to the court as well.
To the statement of Mr. Ramon. Isn't it attached to the statement of Mr. Ramon?
Is it attached there as well? Let me just...
That's what Mr. Tabang said.
It should have been attached.
He said it's an annexure to that agreement.
Yes, Your Lordship, it was an annexure. I just want to highlight. Is it attached? It's not attached. Why not? Your Lordship, it appears it's not attached, but it was submitted as an exhibit in the High Court. I'm informed by my colleagues who prepared the record that it is not attached.
Because I had the impression Mr. Tabang said that maybe he refers to it as attached, and what you've also read is it's attached here too.
It is attached. It was attached, but it was marked as a separate exhibit, as Z22 in court.
Is that what you want to hand in?
Yes, Your Lordship. I just wanted to illustrate a point with regard to the backdating.
Well, what do you say, Mr. Tabang? If it was it was used in the High Court, it was an exhibit, you can't really object if it's handed in, can you? Unless you have it somewhere.
I want to be clear on one thing. It was not, in fact, the attachments to this, the alleged attachments to this that are referred to in the statement, they were not put together as annexures to this statement in the High Court, but it was submitted on its own, and where there were other agreements that were dealt with, they will be brought in subsequently on their own, but not as annexures, as no.
Yeah, can you object? If they were handed in as an exhibit, surely then they must be before us too.
Yes, including Lord, I'm given the instructions because at the High Court I only represented one of the appellants, appellant number 4. There was a time when I was not there in the proceedings. But my instructions are that even the JR 166 that are alleged, they were never attached as part of the submissions to the High Court.
Oh, sorry, let me hear what Mr. Ludebe's got to say.
Your Lordship, at the list of exhibits, the first file, bundle of exhibits, this is volume 1, where the list of exhibits is indicated. Yes, Your Lordship. Yes. Okay, it's not numbered, but it's number 183 on the far left side. Yeah. Just in top of Mr. Jose Ramon's statement, there's an indication there, exhibit Z22 agreement, no page number. That agreement is not there. That agreement, Your Lordship...
That you've got there that you want to hand up.
It's the same agreement that I have here, Your Lordship. Oh. It was submitted as an exhibit, but I don't know for whatever reason, it does not form part of the bundle of exhibits.
Maybe you can, I don't know. Yeah, well then I can't see how they can object to it being handed in, but it's supposed to be there and it was an omission.
Speaking for myself, we are...
Your Lordship, if it was on the record as a separate exhibit, we don't have a problem. But the analogy that I was trying to clarify is that to say that it was put together as an annexure to that statement, together with all the costs, that was never the case. The statement was submitted as an individual.
That is part of the record.
Yes, but if it's part of the record and it was submitted later, we don't have any... Yes, but
that's what we hear.
Yes, but to allege that it was subsequently maybe exercised from the bundle of like an affidavit with an exchange, that was...
It doesn't matter. It didn't.
Yes.
It's in the index and it's supposed to be part of the record, unless...
If it appears there, we can deal with it.
Yes.
If I may just have a few copies, I've given one to my colleague. It appears I can only find 2 copies, I don't know, but it's fine, I'll just give my copy to the court as well.
Six, you should be able to say whether you object that he hands up the documents that he has, which could have been part of the record, although not attached to the exhibit. You should be in a position to say, I object or I do not object.
Remember, we are sitting here as a court of appeal, and our competence is circumscribed within the 4 corners of the record. So this explains why it is necessary for parties to agree that this matter was presented in the court below or it was not presented. Because if it was not presented, it cannot be brought before us, because we'll be called upon now to judge what happened in the court of court using documents that were not before that court. And that is unacceptable. So once you accept that, yes, it was submitted as an exhibit, but it does not appear as part of the bundle before the court now, then it says it can be handed in.
Let me just compare with our letter phrase just to clarify that.
negotiating. Tell us, was this ended in the court below or not? If it was, then we would like to have it.
Your Lordships,
No, I just wanted to find out from
Patela.
Mr. Patela. What?
It's got an exhibit number. Surely it wasn't sucked out from the air. The court must have given it a number, so
We were advising our letter friend to refer you to the specific record. Perhaps he would like to refer you to page 1626,
1,
1626
of what?
of volume 14,
Is it the normal
volume 14 of the transcription.
1426? 1426.
1626, 14 of 26. Perhaps if we can look there, then we can be able to advance his arguments.
It's there. Is it because you see the document there?
I'm trying to.
No. Are you able to see that document there or not?
I see an agreement between an entity called Fine Seafood and Wanyamba.
Just show him,
Trust.
just show it to him
Yes.
to see whether in fact is the document we are talking
Yes,
about.
that's why I'm referring him to the page so that it's specific.
Show him, go to him,
Exactly.
go to him.
Yes. So then he can tell us whether it's the same agreement.
yes. Your Lordship, it confirms that that agreement is in fact Z22. I just want to refer, unfortunately, he skipped a page, the most relevant page, 1625. This is when the agreement was submitted. At the beginning, I indicate there, all right, if you could take us to page 265 of that document, what is there? What is contained in that document? What is this document? He says it's an agreement of consultation services entered into between Skeleton Coast Trolling and Gwanyemba Investment Trust. And this is the one which was submitted at the next page now as Exhibit Z22. The issues of the fine seafood and Gwanyemba,
Just give me that page number again.
1625. And thank you for counsel for referring us to the page where we could
What
find it.
volume is that?
This is volume
16.
14,
14.
Your Lordship, yes. I'm indebted to counsel for directing us where we can find the agreement where it was submitted.
Yeah. Is that exhibit Z21? Is that Z21?
Yes, no, Z22. Z21, Your Lordship, starts from the previous page. First, we would go through the exhibit. After going through the exhibit, then it's marked on record as an exhibit. So for the Z22, from page 1625, we'll be dealing with the consultancy agreement, and then on the next page, it will be submitted as an exhibit Z22. Oh, yeah. So the one Z22 is in fact the agreement.
Okay, then you can hand up Z22.
As it is, the court, Your Lordship, where's the other copy? Your Lordship, I'll just submit all 3 copies.
As long as you didn't draw a lot of lines and highlights on your document. Yes, you want to show us?
Yes, what I want to highlight, Your Lordship, in cross-examination, much was said about the material misdirection by the court in finding that the agreement was backdated. I just want to illustrate that in cross-examination, I've referred to the pages earlier on where this took place. He was asked if this is the agreement that was forwarded to the witness. That is the 4th applicant, and he confirmed that this is the agreement. And this was done in 2019 when he was asked if this is the one that he forwarded, and he agreed. And from the agreement that is forwarded, which was also attached to the witness statement, the date on which it was supposed to be signed at the last page is 2017. So really, if the court found that there was a backdating, that this agreement was to be backdated, that is not a material misdirection, because from the evidence that is apparent before court, in actual fact, the agreement was to be backdated because the date which appears on the agreement is not the actual date of signature, was not going to be the actual date of signature, it was going to be a date before that.
Saying the agreement was not signed in 2017.
Yes, Your Lordship.
And then the request was it should be signed as if it was signed in 2017.
Yes, Your Lordship.
That's where the backdated comes from. It's not a question of he was told to backdate it.
Yes.
If he signed it, it would have appeared that it was signed in 2017. Is that what you are saying?
Yes, Your Lordship. That is what the state is saying. And that is what appears from the document itself. Because this was provided to the witness in 2019 with a date of 2017. So had it been signed, it would have in instance been backdated to 2017. I think that's just one aspect I wanted to highlight, that there is in instance no material misdirection by the court on that aspect. I also just want to indicate, it has already been alluded to that while he was in custody, even prior to being in custody, he knew that investigations were taking place regarding this matter. This matter was a highly publicized matter. He knew investigations were taking place. Now, in all his dealings with all the witnesses, before even the Anti-Corruption Commission could approach any witnesses, he knew who those potential witnesses were, because he knew which unlawful activities were taking place prior to his incarceration. And he knew that Mr. Kamano would be a potential witness because he knew that the activities that took place with this person were unlawful. And he approached this witness in order to influence the witness to sign an agreement, which is dated 2017, as if such services have been rendered since 2017. Started the case says there, Your Lordships, which deal with interference of potential witnesses. I've referred to the matter of state versus, of Chizo versus the state. My apologies, Your Lordship.
Reverting to your normal habit, which is maybe fine in the smaller courts, but here you must speak up a bit.
Perhaps, Your Lordship, the court is too big.
I'm too far, we're too far away, we can't tuck you.
I'll try to speak louder instead of shouting. I feel as if I'm shouting when I speak louder, and I don't want to be disrespectful to the court. Your Lordships, we've referred to the matter of Chizo versus the state in paragraph 55 of the state set of arguments, where the court, when considering the likelihood that an accused will interfere with witnesses, the court pointed out that, as mentioned, the court did consider the position of the appellant and came to the conclusion that he was well positioned and would likely exert influence over potential witnesses and suspects. And I've also referred to the matter of Matali versus the state, which is more relevant insofar as this particular case is concerned, where the court in paragraph 5 stated that the state laid evidence that the appellant found potential witnesses whilst in custody, the same allegations as this particular matter, in connection with medication he wanted brought to the police station and bring. The appellant was found with 2 SIM cards and 2 cell phones whilst he was in the holding cells. Something also quite similar to the other appellants in this matter. Now, in considering whether there was a real likelihood of interference with witnesses in this particular case, the court found in paragraph 13 that in this matter, the accused is a friend to 2 potential state witnesses, namely Sambi and Victor, and he already tried to contact them whilst he was in custody with a cell phone that he was not supposed to keep in custody. So similarly, Your Lordships, I just want to highlight that at that stage, when he was consulting these witnesses, when he was not in custody, he knew they were potential witnesses. So this also illustrates that there is a likelihood of him interfering with witnesses. Your Lordships, I also just want to highlight insofar as this case is concerned, from the evidence that has been laid in the magistrate's court, we had evidence that he normally takes instructions from the second appellant and Mr. Esau, and he followed those instructions. That was, I'm told my voice is low again. Yes, from the evidence in the magistrate's court, we had, and he also confirmed again in his evidence at the High Court, that he would take instructions from Mr. Esau and from the second appellant, and he could not refuse such instructions. We know from the evidence that has been laid that these instructions were unlawful. I know it has been argued that he has a defense to the charges with regard to Fishco, which was the issue in the magistrate's court, the 75.6 million that was paid to the law firm DHC at the time, that he has a good defense to this. I mean, his defense is that he was working on instructions. That has been his defense all along, the same defense that he brought in the High Court. But we know this was unlawful because funds for a private entity, for a party, a political party, that can never be in public interest. So him already transferring those funds to DHC, well knowing that these are for a political party or for the campaign, that was unlawful on its own. And as the CEO of Fishco, he knew what governmental objectives are and that these are in public interest.
Might have been unlawful, but not necessarily criminals. What would have been the position if all that money had been passed on to the intended beneficiary and he didn't benefit at all personally from it? Surely that may have been unlawful to use that mechanism, but is he then criminally liable for anything?
Your Lordship, when it comes to intention, I think that is what the court is going to. On the issues of intention, even dolus eventualis would suffice in the transfer of those funds. So we also have to look at the issue of recklessness, whether he believed that these funds were for governmental objectives.
The problem that not even 10% of those funds ended up with the intended beneficiary. And the money trail then shows it ended up in entities belonging to entities in which the accused have interest in.
Yes, that is the problem, including JACO, where the state alleges he had a secret interest in. It also received funds, and we know those entities were buying assets on behalf of the appellant. So at the end of the day, Your Lordship, insofar as the state's case is concerned, it is a strong case. It's already been highlighted in the heads of arguments that the allocation letters from the Ministry of Fisheries would indicate the governmental objectives. The party will not be there. He'd signed agreement with the Samheji group of companies indicating that the quotas are allocated to Fishco, and the funds should be paid to Fishco. So he knew where the funds should be. So and he diverted those funds. I mean, insofar as the case is concerned, there is a prima facie case there. We've dealt with that sufficiently in the heads of arguments. I'm not going to regurgitate that. I just want to deal with the main issues before this court, Your Lordship. And we know from what I've highlighted now that apart from taking instructions from, as he claims, from his co-accused persons, he has a direct line of access to the accused persons who have not been arrested in this matter from the Samheji group of companies, because he's the one who used to direct them to divert those funds to other private entities. So if the court has a holistic approach, and I submit that this is what is required in this particular case, for the court to have a holistic approach at all the evidence, the relationships between the accused persons, and if there can be, there's a likelihood of them being influenced to interfere. If the court takes a holistic approach of the evidence in this particular case, Your Lordships, we respectfully submit that there is a likelihood of this particular appellant, apart from his own interference, of him being sent as well to interfere in this particular matter. I also just want to highlight
Why?
Yes, Your Lordship. Or is the court going to the judgment?
I just wanted to know about the monies in Dubai,
In
and
Dubai.
the access to the Dubai people, because speaking for myself, I became a bit unsettled when I heard that certain amounts of money were being mentioned in the record, and yet there was no connection between the appellants 3, 4, and 4, 5, 6, and the Dubai people.
Yes, Your
Would
Lordship.
you like to speak to that issue specifically?
Let me deal with that. I'll deal with that by referring to the record itself. I just want to get to the record. Where's that record? The judgment. If the court will bear with me, Your Lordships, I just want to get to the page. Okay. Page is it? Okay, Your Lordship, it appears to start from page 2756. 2756.
Reference was made to 2756, paragraph 1, when that issue was being interrogated.
On which page was it, Your Lordship?
I think he was talking volume 23. He was referring to the judgment of the court
Yes, Your Lordship.
that appears in volume 23, pages 2756, and was referring to paragraph 1 of that particular page, trying to say they are talking about monies that were in existence, but there was no link between those monies and Dubai.
Yes, Your Lordship.
I think that was the argument.
When that was referred to, unfortunately, I was not looking at the record. I was looking at the decision itself attached on the notice. But my colleague is still looking for the page. I cannot find the corresponding page that is reflected on my on the one that I rely on, Your Lordship.
Was that, you see, with the introduction of those statements in the second judgment, then it meant that in fact it was prejudicial to all the accused in that regard. And this explains why they were saying we should disregard the second judgment.
Yes, Your Lordship. Perhaps to save time, I do not have the page numbers, but I know the page before that. I can just, if the court will allow me. It's not the same.
What you were saying?
Your Lordship, I have the page that was read by the court, where it indicates that I'm thus satisfied that the likelihood of the applicants will, if released on bail, suppress or distort evidence relating to the sum of money is real. Oh, no, my apologies. I have the wrong page number, Your Lordship. I'm just trying to find that page because I want to properly answer the court on that issue. I just want to get the right page.
That particular volume. Remember, you are colleagues and you should be working together
Thank you, Your
so that
Lordship.
you are able to assist the court to do justice.
Yes, there are thousands of pages in this record. It's better if the correct page.
Which volume are you referring to?
At volume 23, Your Lordship, of 26.
23.
The issue is I made notes on a different judgment, the one which is attached to the notice. Your Lordship, I think just to save time, from the time that I read that particular provision, the finding of the court merely referred to the applicants. Unfortunately, the court did not specify which applicants would interfere with the funds in Dubai. But we know prior to that, the court had taken into consideration in its judgment that there is evidence to that effect that there were funds which were paid to Dubai. And we know from the evidence that is led, the persons who were involved. And that does not include the fifth applicant, the sixth, and the fourth, fifth, and sixth applicants, Your Lordships. I just want to highlight that from the judgment itself, it's not clear which applicants are referred to. It merely states that the applicants Your Lordship, looking at the finding of the court of that particular page, that there's a likelihood of the applicants interfering with that sum of money, it in no way refers, as I've indicated, to applicants 4, 5, and 6. And we know from the evidence that was laid before court that this primarily relates to the first 3 applicants. And the charges in terms of the indictment, that is also before court as an exhibit, is in respect of the first 3 applicants, not the last 4 applicants. So for the...
Why should the court then refuse to give bail to appellants 4, 5, and 6 if there was no evidence relating to their connection?
Your Lordships, insofar as appellants 4, 5, and 6, it's not only limited to the interference insofar as the funds in Dubai are concerned. We've also dealt with other forms of interference or likelihood of interference in respect of those applicants. Not
Phones as well?
Yes, because for the 4th applicant, it's with regard to the consultancy agreement, the evidence that we just dealt with now, that he wanted the witness to sign. That is the evidence that relates to him. I'll still come to the other issues of the funds or investments, as they were called, in Angola, because those are the relevant ones when it comes to the 4th, 5th applicants in this particular matter. How many minutes?
In fact, you've only got 5 minutes because of the 15 minutes you wasted this morning, so move on.
Do I have 5 minutes left? Okay, Your Lordships, I'll move on. Is it 5 minutes that I have, Your Lordship? How much time do I have left? I've not.
No, move on a bit, but I mean, we must finish by 4 this whole case. So move on.
As it please the court, Your Lordships. I just want to highlight, insofar as this matter is concerned, I've already partly touched on the 5th applicant, as from the statement of Mr. Kamano, that he was working with the 4th applicant, contacting the witness in this particular case. The issues of likelihood of interference have also been dealt with in the heads of arguments extensively. that there is in fact a likelihood of interference taking into conduct his contacts with that particular witness. And we know from the evidence that has been laid, and they don't dispute it themselves, especially the fifth and the sixth applicants, in relation to the Novanam group of companies, that the invoices that they wrote for payment from Novanam, they never provided any services. They were merely instructed by the fourth appellant to write those invoices, and they were paid for services not rendered. So we know from having a holistic view of the evidence in this particular case that they're also capable of following instructions from the fifth appellant, who was in actual fact sending the fifth appellant to do his bidding while he was in custody. And furthermore, Your Lordship, we know from the evidence that was laid that the sixth appellant, Mr. Mapopi, with regard to the dried fish, he was requested by the members of the ACC to produce evidence of procurement of that dried fish. And what does he do? He produces an invoice to the ACC. That invoice is dated 2020. We know that cannot be the case because the dried fish was procured in 2016. So it's a false invoice. And it's not disputed, furthermore, that the entity reflected on that invoice, Flamingo Commodity Supplies, is a non-existent entity. So if the court takes this into consideration, it's very likely that this is a person who's capable of generating false information. We know from the evidence that has been laid, having a holistic view of the evidence, Mr. Hatguilipi, that's what he tends to do. The second applicant, he wants people to generate documents, false documents, to justify the commission of these offenses. I mean, it's very likely for these accused persons to do that as well. I also just want to highlight that, especially in this particular case, where we have a very strong prima facie case against the accused persons in this matter, and the sentence is most likely going to be a lengthy sentence, which will be imposed, a custodial sentence. That will be an inducement, a very strong inducement for them to interfere with investigations in this matter. Moreover, the voice.
I agree with Maron Detse.
Yes, I hear the voice. It's going low. I'll raise it again, Your Lordship. It's exhausting speaking for hours. Yes, I just want to highlight that on the issues of interference, the court was correct in finding that there is a likelihood of interference by the accused persons, because it does not matter to these accused persons whether you provided a statement, whether you've collected the exhibits, because insofar as this syndicate is concerned, they'll even approach the investigating officers in their own case to release exhibits. If they can do that to investigating officers, really, what are witnesses to the members of the syndicate? Your Lordships, I think now, let me just move on to another aspect. I think the one that was of interest before my time runs out, the issues of public interests and interests of the administration of justice.
Issue of what?
Public interest.
Oh.
Interest of the public.
Why do you want to go there? I mean, because the court, our court, didn't go there.
Yes, Your Lordships, because at the end of the day, when this court is seized with this matter, it depends. If the court finds that the decision was wrong, I don't know what the court's finding is going to be. But if the court finds the decision was wrong, then the court ought to give a decision that should have been given by the High Court. In essence, that is the only reason as to why the issue of interest of the public has been raised, Your Lordships. As a starting point, I'll be very brief. I know the time is not with me. It was requested from the court on the definition of the interest of the public. Not sure if the court still wants that to be addressed. I can
Address it quickly.
Yes, I can quickly address that, Your Lordships. Because the starting point is Section 61 of the Criminal Procedure Act. It makes provision that if the court is satisfied the accused is not going to abscond or interfere with investigations or witnesses, in the opinion of the court, it can still deny bail if it's not in the interest of the public or in the interest of the administration of justice. Now, when it comes to the issues of the interest of the public, I think that concept, it speaks for itself. It's what's in the interest of the public insofar as any particular case is concerned. Generally, if the court has regard to the Charlotte Helena Botha matter, in that particular case, the court had outlined the factors which would be indicative of the interest of the public. And the three factors which were outlined therein include public outcry. It's not a deciding factor, but it's something to take into consideration if it's genuine and spontaneous, but it's not a deciding factor, but it must be taken into consideration. Pronouncements of the court, that was another aspect that should be taken into consideration, because the pronouncements of the courts, the judgment, would reflect what constitutes public interest. Because this concept would differ from case to case. And the courts have to define what public interest is, or the interest of the public. And apart from that, legislation as well would indicate as to the interest of the public. And in this particular case, we have the provisions of Section 61 of the Criminal Procedure Act, which was concerned with accused persons who have been absconding, despite them having satisfied the court that they are not going to abscond, and they still abscond. So Section 61 was enacted for that purpose, and that is a reflection of the interest of the public. We have the provisions of POCA, we have the provisions of the ACC Act. Those will all be reflective of the interest of the public. Now, just to cut matters short, Your Lordships, when you are dealing with the interest of the public, it's in natural fact a lucid concept. Generally, the examples that are given is that the interest of the public, for example, in a matter where an accused person faces serious charges, let's say there are serial killings which are alleged against this person. He satisfied the court, I'm not going to abscond. He satisfied the court, I'm not going to interfere. Should that person be released? No, it's not in the interest of the public because it poses a danger to the public. Now, insofar as the interest of the public is concerned, in the matter of Charlotte Helena Botha, also in the matter of Duplessis, I believe also in the Gustavo matter Supreme Court judgment, the courts also touched on this. Yes, Your Lordships, just for purposes of time, I will not have time to quickly look at the specific page. But in instance what the court said was this, that even if the accused convinces the court that it's unlikely or improbable they are going to abscond or interfere with witnesses, but in cases where there's a prima facie case against that person and the likelihood of conviction is high, if the court is of the view there's a reasonable possibility they will interfere, then in accordance to the provisions of Section 61, which has given them wider powers, they can, in fact, now refuse bail on that basis. But insofar as this case is concerned, the interest of the public is also quite clear, and I just want to touch on the question that was posed regarding the funds in Dubai. Because we have members of a syndicate who have utilized their public offices to benefit from the resources of Namibia. The funds which were transferred to Dubai, these are derived from quotas meant for governmental objectives for the benefit of the Namibian people. Now, is it in the interest of the public to release the appellants on bail in this particular case when those funds have not been accounted for? They have not informed the court what has happened to those funds. So the appellants are going to be released on bail, and they benefit from public funds which have not been returned to the state coffers to benefit the public. So is that in public interest? I respectfully submit not, Your Lordship. And the same applies for the other appellants in this case, the fourth appellant and the sixth appellant, who testified, and we know from the evidence that was laid that the funds which were received, which were an issue in this particular case, were transferred to their entities. And what they testified to the court is that these funds were invested in Angola. And from the evidence of the fifth appellant, Mr. Shidufonia, if he's released, they will continue their project in Angola. He's just being held back because he's in custody. We are talking about public funds here. So these funds could be used for the development of schools, hospitals. We know the state that these are in. So really, is it in the interest of the public to release these persons on bail for them to continue benefiting from public funds individually? No. And that is the whole concept of the interest of the public. And I think maybe just to get a better definition of this, Your Lordship, it would also be appropriate just to have in terms of the rules of interpretation, just to have a look at the ordinary dictionary meaning of what constitutes public interest. That would be the starting point. But these matters that I've just highlighted, Your Lordship, is just to illustrate the public interest of the public in this particular case. We are not merely just saying here that, no, there was a demonstration, that's the interest of No. That is one factor, definitely. It has to be taken into consideration. It is a factor, but it must be considered with other factors. That is public interest. And I think just to close off on the concept of public interest, Your Lordship, I just want to highlight that when dealing with public interest, one very important factor, as I indicated in the Charlotte Helena Botha matter, that the court must look at the judgments or decisions that have been delivered defining public interest. And one of these definitions that can be found in our judgments, some of the judgments are cited in there, is that if there's a strong prima facie case against an accused person, and the likelihood of conviction is high, the likelihood of imprisonment is also high, then it will not be in the interest of the public to have the persons released on bail. Yes, I see the court is.
It must be finished.
No, I can push Your Lordship. I'll comply with the court's order.
No, half past you'll be finished, and then each party will get quarter of an hour to reply.
As it plays the court, Your Lordship. And just to highlight, because now we are concerned with what decision that this court is going to give. We know Mr. Ngipunya's bail application was a bail application on new facts. So really, the decision of the magistrate's court was challenged in the High Court. It was dismissed. The High Court found it was a proper decision, that there's a likelihood of him interfering and it's not in the interest of the administration of justice and public. So that stands. That decision stands, Your Lordship. I just want to... Now I'm concluding, Your Lordship. I'm going to stick with the time. Yes.
Highlights.
No, I'll conclude, Your Lordship. Let me just quickly touch on one other aspect that was raised. And this is in relation to the ACC, the powers of the ACC to investigate cases.
In that regard was, what is the intended objective with raising that point? Are you saying, is it being said that the evidence collected by the unauthorized investigator will be inadmissible and therefore it will not be able to speak to the issue of the seriousness of the crime in question? What do you understand to be the purpose of that attack? And perhaps related to that, is that not a matter that will actually much more conveniently be raised at the trial when shooting down the evidence to say this evidence is inadmissible? Is that a matter for bail?
Not at all, Your Lordship. And in actual fact, that was also the view that was held in the matter of Grant Noble versus the state. It also forms part of the record, exhibits, volume 2 of 3. Should be the last judgment. There was an issue of the validity of the search and the lawfulness of the warrants in this particular. This is what the court said. As earlier stated, it was the appellant's argument that the court misdirected itself in not determining the above-mentioned issues. Bail application is not a trial but an inquiry. The court, at this stage, is tasked to have due regard to the evidence adduced before it as a whole and make a finding whether the state has established a prima facie case against the appellant. If these issues have to be decided during the bail inquiry, this may amount to prejudging the issues to be decided during the trial, which in turn may have an adverse effect on the criminal process. Grant Noble versus the state is the last case in volume 2 of the state's exhibit.
Where is it?
It's
Bundle of authorities?
Yes,
Whose
Your Lordship.
bundle of authorities?
The state's bundle of authorities, volume 2 of 3. I just want to highlight volume 2 of 3, Your Lordship, the last judgment in that bundle.
Two last judgment.
Yes, I just want to highlight what I understand from their arguments is simply this. If those charges of money laundering and racketeering, those will fall away. But insofar as the charges of fraud, charges under the theft, charges under the Anti-Corruption Act, those will still stand. But from the arguments, they consider the charges of money laundering and racketeering to be more serious charges than fraud, which is not the case. Because in terms of Section 61 of the CPA, money laundering and fraud do not appear there. It's only fraud and theft which will be affected under Section 61. Moreover, looking at the indictment, those charges of racketeering and money laundering, they're derived from the same facts with the charges of fraud and theft. So really, if there was something completely separate, that we are looking at separate fate, I'd understand that, yes, okay, fine, maybe the more serious charges have fall out. No, they don't. It's derived from the same facts, the same amounts are involved. So really, the story remains serious, even in the absence of those charges. Your Lordship, I know my time is up, so let me just conclude by saying that the state respectfully submits that insofar as this matter is concerned, looking at the final decision of the court denying bail on the basis that it did not be in the interest of the administration of justice and there's a likelihood of interference, the court was in actual fact correct in its finding, Your Lordship. I think, let me just see if there's anything else, if the court will allow me. Yes, Your Lordship, that is the state's argument.
Thank you, Mr. Dembese. Mr. Soni?
Oh, sorry.
I don't intend, I hope I don't have to take all 15 minutes. May I raise the first issue raised by our learned friends for the state, namely that our notice of appeal does not include the issue of onus. And I know they've put it at a very narrow level. I just point this out because it is a major part of our case. Because at paragraph 13 of the notice of appeal, we say significantly the learned judge declined to grant bail not because there was evidence justifying a further deprivation of a significant fundamental right, namely liberty, but because the appellants had failed to discharge the onus allegedly resting on them. With respect, it is not so that in a bail application an accused bears the onus of proving that he ought to be released on bail. The learned judge's ruling to the contrary constitutes a material error of law. Now, what we have done in considering the matter after the notice of appeal was filed is refined the position so that we say in respect of this application, the court committed a material error of law. Now, on that basis, we cannot be, with respect, non-suited for putting our claim wider than it really is. We are not expanding the basis. We are, in fact, limiting the basis on which we rely on the material error of law. So we submit that on that issue, the question of our being able to persist with the onus issue remains intact. My learned friends have also indicated that they had led evidence which was undisputed about alleged interference or non-compliance with certain matters. I just want to, and I'm not going to be long about this, let me deal first with the allegations against the second appellant. Now, the allegation against him is that he gave money to somebody, 250,000 rand. And we must remember this is all done while he is in prison. Where he would get 250,000 rand is never explained. But this issue was specifically dealt with the investigator who gave evidence. And it appears at volume 18, page 2052. Well, it's page 2051, where Mr. Kanyangela concedes that after there's 2 points about this. Mr. Kanyangela himself didn't investigate that matter. Somebody from the ACC reported to him. The matter is taken to court. This person pleads guilty. A second charge against him is dropped. The issue, though, is it was put to Mr. Kanyangela, look, an allegation is made. You are investigating the second appellant. Did you ask him for a version? Did you say to him, look, this allegation has been made? It's a serious allegation. It's going to materially affect your case. He says, no, I didn't. I didn't ask him anything. That's what he says at page 2051. And then as regards the case itself, Mr. Kanyangela admits that that person is a self-confessed convict. But he doesn't, on the basis of what he is told there, come to Mr. Hatikabulupi and say, this is an allegation made against you. But what is important about the approach of the state is that if your lordships look at page, volume 1, page 7, this is the second appellant's affidavit in support of his bail application. He says at page 6, paragraph 4. He says, I place on record that the state has charged me in another matter which is pending in the magistrate's court, and it is this matter. Should that matter come to proceed to trial, I intend pleading not guilty to the charges, and I record that I deny any wrongdoing as alleged. As a matter of fact, as is evident from the disclosed documents of the Anti-Corruption Commission, I am in fact the targeted victim of a failed plot to extort monies from me. Whilst I have not attached such documents to this application, my legal practitioners will have such at hand during the bail hearing should the court wish to peruse them. So that's not the approach of a person who wants to hide something. He wants to deal with it. But no, that invitation is not accepted But today our learned friends come and say there's been no answer to it. Well, with respect, Justices, there is a complete answer to that. And all we have is an allegation of a convicted person, a person convicted by his own mouth. Can I then turn to the allegation made against the first appellant as regards the so-called extradition regarding Dubai? At at volume 18, that evidence, incidentally, is based on a report compiled by Deloitte, and that report has already been referred to. And I just want to mention 2 or 3 aspects of that. At page 2045, Deloitte say in the report that as there is no consultations with the persons of interest, which include all the appellants, this report may not reflect full information of all relevant documentation and transactions. Information used for the purpose of this report has been obtained from documents from the ACC. It says, our review was dependent on the completeness and integrity of the documents we received from the ACC. Now, as regards that report contained what is called Dubai searches, a section that is contained, that is titled Dubai searches. And Mr. Kanyangela, when asked about this, is asked, that report was not conducted by you. He says, no, it was not. And then he says at page 2046, now, did you ask the first appellant about this? Because Deloitte were not allowed to talk to the first appellant, but Mr. Kanyangela says, no, I didn't go to him. And then the following is put. Had you gone to him, this is what Mr. Shanghala would have said. Says, among the matters that were contained in the information given during the various proceedings, the court proceedings, and in affidavits, was that there were certain dealings that had taken place in Dubai. As a lawyer, he was checking various aspects relating to the law in Dubai in relation to Namibia and what information Namibia would be able to get from them. You are not in a position to dispute that, are you? And he says, no, I'm not in a position to dispute that. Now that's the totality of the evidence that's on record relating to this matter. But the third point is, again, this has nothing to do with interfering with evidence. And as has been pointed out, the fact that phones were found in their possession is not a basis to say they were interfering, because there is no proof of interference. May I address one issue that I've not been asked to address, and I know I'm forcing myself onto the court on this issue, and this is the issue of public interest. Obviously, the issue would arise only if your lordships come to the conclusion that in respects of appellants 1, 2, and 3, the decision of the court was wrong. And the lordships come to the conclusion that based on whatever onus you accept, that the 3 appellants are entitled to bail, but on condition that the public interest is not adversely affected. Now, may I make this point? I made it much earlier, starting with the decision, with the the judgment of the court Arco. Go back to the introduction where he says, an accused person cannot be kept in detention pending his trial. The presumption of the law is that he is innocent until his guilt has been established. The court will therefore ordinarily grant bail to an accused person unless this is likely to prejudice the ends of justice. That, I remind the court, is prior to Section 61 being introduced. So even at the time of Atchison, the notion of the ends of justice not being prejudiced was there. And the submission we make is that when one considers the question of public interest, having regard to the totality of factors, the first three factors are, is the accused likely to stand his trial? The second, is he likely to interfere? And the third is, what prejudice is to the public? And in deciding whether or not that qualification, as it is now put in Section 61, the public interest requires otherwise, what the court has to take into account are factors other than those. And that would, for example, depend, and it's easy to say, where there is a domestic violence matter that a person would in some ways interfere with the person whom he has been acting violently against. If it concerned a pedophile, and the pedophile ticked all three boxes, are the children safe in those circumstances? In a case like this, assuming the appellants were to remain in their positions, then is the public interest, if they were in those positions? Well, obviously it's not in the public interest that persons who are facing such charges should remain in public office. The question, though, is, should they be kept in custody? And the question and the answer, with respect, must be in line with the Constitution. What the public would expect of the court is a proper consideration of all the matters, including the reasonable expectations of the public. The reasonable expectations. And the reasonable expectations of the public must be that the provisions of the Constitution, the provisions of the law, are not breached to the point where, in attempting to protect the public, as it were, a decision is reached that is antithetical to what the Constitution expects. So we submit that it is a wide discretion afforded to the court that would depend on the particular circumstances of the case. And to the extent that the public expects that this court, despite its best endeavors to find reasons not to hold the appellants in custody, that it does so, that would not be in the public interest, because it will be a betrayal of the trust that the Constitution reposes in members of the judiciary. So we submit that at the end of the day, the decision on public interest cannot be so far away from what ordinary reasonable people expect judges to do in protecting their interests. And we submit that in a case where the accused have been in custody for 3 years now, it is not in the public interest that they be kept in custody. Because today it may well be these accused, tomorrow it may be other accused, and that undermines the entire justice system. It must be this fair play that the English judges of old used to talk about. Those are my submissions, Judge.
Yes, Mr. Patel.
Your Lordships, I intend not to take my entire 15 minutes, which I'm entitled to. My contentions that I made earlier, especially on the law of the facts, remain untested and uncontested. You will have noticed that even when the state, despite the best endeavors of my learned friend, who is one of the most gifted legal practitioners, he couldn't find a reason either in the record anywhere why Mwapopi was found not to be a suitable candidate for bail. I'm talking about appellate number 6. I also accept, and I'm delighted with the concession that came from the state submission, that the judgment itself erroneously concluded. The judgment concluded erroneously that appellates 4, 5, and 6 were culpable in respect of the money in Dubai, the $4 million US. That was not their own baby to kiss. They had nothing to do with that. And I submit that on those grounds, and the ones that I made as well earlier in my submissions in chief, they remain sustainable, that the Court of Appeal's judgment was and remains an injustice to appellants 4, 5, and 6. You will note that in the heads of arguments of the state, even in the oral submissions, some kind of attempt was made pertaining to the complaint about the admission of appellant 4, bail on new facts. But not much was made in argument. Your Lordships, this creates a difficulty for us. We brought an appeal. We were forced by the requirements of the rules of engagement to set out what exactly are the reasons why we say the judgment of the Court of Appeal must be assailed by this court. They looked at those grounds. We know that lately it's a requirement of this court that the respondent cannot simply say, I oppose. They must also set out the grounds why they are opposing. There was no cross-appeal whatsoever from the state relating to whether it was improper, incorrect, or otherwise to admit the application of appellate number 4 based on new facts. But now, for the first time in the heads of arguments, we see this argument, which we say is neither here nor there, is not relevant. The one that the Court of Appeal could perhaps have made an error by admitting the 4th appellant, bail application based on new facts. And therefore, that's why we say, we submit that their Lordship should not even be bothered to deal with that aspect. It was never an issue, and there is no cross-appeal from the state. We also put forward that the issue of backdating, if the court drew an inference that this agreement, when you look at it, the totality of it leads to an inference that the intention was for it to be backdated, then say so. But when the court says there was evidence that the witness was requested to backdate an agreement, that's an issue of fact. And we say that was not correct. No matter how, from which angle you look at it, it was not correct. So the interference that was relating to this witness statement, moreover emphasis being placed on backdating of agreements, contaminated the line of reasoning. And that's why we say this honorable court will be entitled not to rely on the findings of the Court of Appeal in that regard. Number 2, or the last point that I want to make quickly, there is a submission that is being made which completely misses the context. That my client, or the 4th appellant, was simply getting instructions. He demonstrated that he was always following instructions of certain accused, co-accused. This argument, we have seen it in the High Court, but we also take issue with it because it misses the context within which the instructions were executed. He was an employee of the company. There were these gazetted legal instruments, including the Marine Resources Act. There were also these agreements, a plethora of agreements that would be gazetted by the state, detailing that once the government has made a determination that those are the governmental objectives, he had to follow them. He had no power whatsoever to deal with that. So he could follow them because it was in the context of an employment relationship. He is no longer employed there, that is a fact. And the co-accused are also no longer occupying the positions that they were occupying. So there is no evidence that was left before the court that at any time after he has been relieved of his positions, as well as the other co-accused, he has followed any of the instructions from those people. And so therefore the argument we say, my lord, that it's not sustainable. We also want to clear one thing, because although our learned friend was, once or twice tried to specify this, the issue of the cell phones that were found, none of these appellant 4, 5, and 6 were ever found with an illegal, unlawful communication device, including a cell phone or SIM cards, nothing of the sort. So that we clarify it, so that we don't want this to live in the mind of the court that the same brush, because our learned friends have the responsibility to the facts. When they say that certain instruments were found, they have to exclude my clients from those findings. We submit that earlier on I had to deal with the question of public interest. But I emphasize that having looked at the authorities, your lordships, it seems like even while public interest or interest of the public is in the mind of the court, the overriding constitutional obligation of our courts pertaining to the presumption of innocence is never too far. It's a balancing act, and we submit that the court will have to consider all these factors. At the end, is it fair to keep a man that may ultimately be exonerated in jail for the proceedings where over 320 witnesses are going to be testifying? We submit that the presumption of innocence, which, as was stated, although is a bit dangerous, and I accept this, your lordships, that often when one comes to the apex court, it can be quite dangerous to cite the cases of a high court. But we agree with the submission, because the observation of the court here, because it has not been upset, at least on the basis of what we have cited here. In the case of S versus Jonah, we have referred to this in paragraph 203 of our heads, because from basically paragraph 201, that's where we deal with interest of the public and interest of the administration of justice, where the court said the following pertaining to the granting of bail. It must be, however, be borne in mind that any court seized with the problem of whether or not to release a detainee on bail must approach the matter from the perspective that freedom is a precious right protected by our Constitution. Such freedom should only be lawfully curtailed if the interest of justice so require. The fundamental objective of the institution of bail in a democratic society based on freedom is to maximize personal liberty. The proper approach to a decision in a bail application is that the court will always grant bail where possible and will lean in favor of and not against the liberty of the subject, provided that it is clear that the interests of justice will not be prejudiced thereby. The interest of the public justice, Frank, my submission on that note, difficult concept as it is that People that are prosecuted for crimes or that have committed crimes must be prosecuted. One may add, be prosecuted timelessly. And if convicted, they must serve their sentence. But where there are other factors, such as bail, that have to be considered, including the presumption of innocence, it's in the interest of the public that those also must be given. Only those people that don't deserve to be admitted to bail must be refused bail. In fact, giving the appellants bail does not say that the court is pronouncing itself on their guilt and or their innocence. Those are matters for the trial court. And we
know that, Mr. Tabet?
Yes. So we have no further submissions, Our Lordship. Those are our submissions in reply. We believe that our case is still intact. Wherefore, we pray for the relief that we have advanced in our heads of arguments, as it pleases the court.
Mr. Patella? Yes, it leaves me just to thank all counsel for their heads of argument and their oral argument. We will obviously have to consider the matter but further, and we will do that. And once the judgment is ready, we'll let the parties know. So the judgment is reserved, and the parties will be notified when it's ready to be handed down. Thank you. The court will adjourn.